In the meantime, let's move on and talk about nearly 4 months after reserving its decision in the vital matter. The Supreme Court is all set to pronounce its interim order in a batch of petitions challenging the constitutional validity of the Waqf Amendment Act. Let's revisit as far as the sequence of events are concerned. It was on the 5th of April when President Draupadi Murmu gave her assent to the Waqf Amendment Bill 2025, which was earlier passed by the Parliament after heated debates in both houses, which is the Lok Sabha and the Rajya Sabha. Now, this was then followed by a batch of petitions that was filed before the Apex Court, challenging the constitutional validity of the Act itself. They contended that this Act was discriminatory towards the Muslim community and it violates their fundamental rights. Now, after 3 consecutive days of arguments from all parties involved, a 2-judge bench of the Apex Court that was headed by the Chief Justice of India, B.R. Gavai, and including Justice Augustine George Massey, had reserved the order on the 22nd of May. Now, today, the same bench will be pronouncing its decision, and the centre, which has defended the Act as a valid, lawful exercise of legislative power, while filing for a detailed reply in the Supreme Court, the government had requested it to dismiss the batch of petitions challenging the constitutional validity of it. Let's get in a word from Harish and Kritika, who are joining us live right now. Good morning to both of you. Harish, as we speak, as far as this development that is now concerned, this matter that was taken up in the court and was vehemently argued from both sides, we are looking at an interim order that would be announced today by the Supreme Court.
Yes, good morning, Amita. All eyes on the Supreme Court, which will pronounce its judgment on a plea by nearly 100 petitioners who had challenged the Waqf Amendment Act 2025. They seek staying the operation of the Act till the Supreme Court finally adjudicated on its constitutional validity. And as you rightly said, judgment was reserved on May 22. Key petitioners include Asaduddin Owaisi, Indian Union Muslim League, Mahua Moitra, Jamiat Ulema Hind, RJD, CPM and CPI. While the petitioners had called the Act as unwarranted interference into the religious affairs of Muslim community, as you rightly said, Centre has defended the Act, saying Waqf body is a statutory body, not a religious body, and courts cannot stay an Act passed by the Parliament as there is a presumption of constitutionality. Primarily, Amita, the petitioners are seeking stay of few provisions in the till Supreme Court pronounces its final judgment on validity of Waqf Act. That is number 1, no Waqfs, including Waqfs by user, whether declared by way of notification or by way of registration, be notified for time being. Number 2, petitioners said way Waqf Act has been drafted, majority of the members in Central Waqf Council and State Waqf Board will be non-Muslims. They want no appointments would be made to the Central Waqf Council or Waqf Boards in the state till Supreme Court's final adjudication. Number 3, the third issue, which is identified, relates to provision that says a Waqf property will not be treated as a Waqf when the collector conducts an inquiry into ascertain if the property is government land. Petitioners seek a stay on that. Regarding supreme role for the collector or senior government official in a dispute between government and Muslim individuals, they say
so it's like government through our viewers as far as when it comes to the issues and the points that you have raised, Harish, in detail. Kritika is also connected with us. We'll just put out exactly when it comes to the main bones of contention with regards to the Act itself that is being challenged by the Waqf Board, and there are other petitioners as well. Let's in the meantime take a look as far as when it comes to the Waqf deadlock is now concerned. Contention 1 is Waqf by user. What it means that anyone can donate to the Waqf. What the government wants is only practicing Muslims can actually donate, especially when it comes to land. What the opposition is now deeming, that saying do not change when it comes to the current provision that anyone can donate to the Waqf. When we speak of religions that is being used as the basis of claim, the government wants that returning to the original Congress era clause that shouldn't be done. However, on part of the opposition, it wants no change as far as when it comes to the current positions or the provisions are concerned. Now, when we take a look at the other contention, which is non-Muslims on the board. Now, what the government wants is 2 non-Muslim members to be in the Waqf Board, as it is being stated that it is a constitutional body, it's a statutory body. However, when it comes to the opposition, it maintains that as far as the Waqf is concerned, it should be led by only Muslims. Now, as far as when it comes to the another contention is concerned, let's put out the contention number 3, which is when it comes to the claim to government property. What the government here wants is when it comes to subject to adjudication by the state level officer. On the other hand, the opposition claims that this issue needs to be addressed only and only by the Waqf tribunal. That should be having the last word in case of any dispute. Another contention as far as when it comes to the other communities within Muslims are also concerned, it seems to be inclusive of Bohras, of Aga Khanis as well. Now, the government wants separate boards and decision that should be actually left to the states to decide. But however, the opposition does not want any separate boards. That should include even when it comes to the Shia community itself. Let's go back to Kritika on this, because Kritika, we have seen this issue itself that has sparked debates over legal principles and the denotification of Waqf properties. Advocates have been arguing that it is a departure from constitutional norms, while the government has defended its constitutionality.
Well, exactly. The government, through Solicitor General Tushar, had also, in the proceedings, in fact, laid out that the statutory recognition that the creation of Waqf gets was also through legislation. And as for these amendments, this can also be taken back because creation of a Waqf is not essential to the practice of Islam. This is one of the main arguments that, in fact, the union government has also been presenting. However, we have seen time and time again,
losing that connection with you, Kritika, but as far as when it comes to this development now is concerned, as we are expecting the Supreme Court to pronounce its interim order on the Waqf Act, as far as when it comes to the matter that was reserved, the decision back on the 22nd of May. But this bench that was headed by Chief Justice B.R. Gawai had reserved the interim order after 3 consecutive days of arguments from all of the parties that were said to be involved. We'll keep an eye out on the developments today as when the court proceeds with this matter. Thank you very much, Harish and Kritika, for joining us here on the broadcast. With that, we head into a short break. The war is not just on the